Good morning. If you wouldn't mind, please rise and join me for the Pledge of Allegiance. Thank you. You'll all be shocked to hear that I'm going to do something a little unorthodox this morning. Yeah, really. So we have someone here that the committee wants to hear from, and it's on the second bill. So what I'm going to do first is I'm going to open House Bill 1087's executive session, and I'm going to recess it for a few minutes. Hereby open it, and I hereby recess it, and then I'm going to open the executive session on House Bill 1203 and invite the judge to come up and address the committee. Yes, sir.
Just as a matter, we ran into this problem on children and family law. Procedurally, it would be better if you reopened the hearing on 1203 rather than hearing testimony in executive session. We were cautioned by the clerk that you can't hear testimony in executive session. It's not at the discretion of the. I'm just reporting what I heard. So my suggestion would
Sometimes it's better not to report things you hear. But that's well taken. Unfortunately, I can't undo what I just did. I opened an executive session. I can't revert back to hearing without a motion or some type of other thing. So I'm going to have to just
I'm
caution
just
to
going
the
to cover
wind
my eyes then.
and invite the judge to come up and not give testimony, but elucidate on a document she gave us.
Thank you, Mr. Chairman and members of the committee. I appreciate the opportunity to just provide some clarifying information. I listened to the hearing that you had before and felt that there was some information that might have been missing that would be useful for you to have in terms of making your decisions on this bill. So I want to start, I guess, with an example. A real world example of what would happen if this language were in statute right now. So for instance, let's assume a person was charged with aggravated felonious sexual assault. Okay. Eventually that case is going to go to trial in the Superior Court. Starts in the Circuit Court, but would end up being bound over and being tried in the Superior Court, presumably in front of a jury. So let's say with this example that the bail order required that guns were taken, whether it's a criminal bail protective order or a regular bail order that a judge ordered guns taken as part of the bail conditions on this charge. Okay. So this is, strictly a criminal charge at this point. So let's say a year and a half later, this is going to trial. Okay. During that year and a half, let's say, another alleged victim files for a stalking petition and gets a civil stalking order against the same defendant. Okay. And let's say that we go through a jury trial and for whatever reason, maybe unrelated to the actual issue at hand, the person is found not guilty in that trial. The way this legislation reads is that at that point, that Superior Court judge would then be required to immediately order the return of firearms to that defendant without doing a background check. And the problem with that is that Superior Court judge may have wouldn't have any idea that there has, since those criminal charges have been filed, that another protective order was put into place, which would then require guns to be taken. So it's putting the judge in the position of ordering return of firearms to somebody who is not eligible under the law to get their firearms back. So that would be that's a real world example of how, if this legislation were in effect today, that could happen. Okay.
I actually had contemplated a similar but different scenario. I was thinking along the lines of the person was out on bail and went to visit someone in Florida and ended up charged down there. and came back here and was, without a background check, there would be no III record to show that there was an active outstanding.
Right. So there are many, I could give you all
Yeah,
kinds of
there's
different
yeah,
examples
yeah.
of how there could be issues with how this would be if it were enacted, how it would be problematic.
Okay.
But then the
I
other,
see.
so that's sort of a real world example of some of the concerns here. And then I also wanted to provide you with some information about our return of firearm process that we now have in the circuit court. And actually, it's been adopted by the Superior Court as well. So then this is based on some of the questions that members of the committee asked at the last hearing. So last year, the legislature passed and the governor signed into law HB 506, which was a major change to return of firearms in the statutes. And that amended RSA 159D:4. All right. So when that was enacted into law, we then looked at it and said, okay, how do we implement this in our systems? One of the issues that we had is that there are some pieces of that actually conflict with another statute, well, two other statutes, with and I won't list, 173B, which is the DV statute, and I think it's 169C, which is the stalking statute, because those statutes have very specific requirements for return of firearms. So what we did is we spent 5 months with a committee internally in the judicial branch and with the Department of Safety, coming up with, okay, how are we going to implement this, given that we have some conflicting statutory requirements, and we have to figure out how to implement it. So what we did is we came up with a standardized process for every type of return of firearm that met, in essence, the requirements and the spirit of both statutes, or all three statutes. And so now what we have is a standardized process for anybody, for any type of return of firearm, no matter what the reasons for why they were taken in the first place, that we have this standardized process so that everyone's doing it the same way. The Superior Court has adopted it as well, so that now all trial courts in the state have the exact same process. That process requires that a defendant file a petition, which they can do. There's no cost to it, anything like that. They file a petition for return of firearms with the court. We developed new forms. We developed these forms with the Department of Safety. There's a whole slate of new forms as to how this works. And once they file that petition, that petition has accompanying it an affidavit about all of the disqualifiers. So we know right up front whether this person, according to them, have any disqualifiers or not. Once that happens, the gun line report is ordered, and the Department of Safety has 10 business days to get that report of proceed or deny back to the court. That 10 days, because I know this question came up at the hearing, that 10 days is in the statute. That's what the legislature decided was the right thing to do with in the last session. So they must return that within 10 days. Assuming they do that, if there's a disqualifier, the person from the gun line at the Department of Safety is the one who has to come to court at a hearing and explain and prove by clear and convincing evidence that there is a disqualifier.
So the burden is on the Department of Safety.
The burden is
not
on the Department of Safety,
Okay.
correct. So now this standardized process happens very quickly. It all happens within a maximum of 15 days.
15 days from the time the owner of the firearm submits the petition
Correct.
to the decision on whether to give them or not.
Correct.
How long does it take? So at that point, assuming the decision is to return the firearms, what happens? Does the court issue an order to the police department?
The court issues an order. That order is sent to the police department, but is also, I actually think it's the defendant's
He's no longer the
response.
defendant.
Correct. It is the litigants or the petitioners, whoever has that order. It is their responsibility to take that order to the police station, present it, and present that certified order for return of firearms.
And there's no cost to the
Correct. There is
litigant
no
for that
cost to the
form?
litigant for
And
any of that.
is it a complicated form? I mean, is there criminal jeopardy attached to that form if they don't fill it out correctly?
Not the form, there certainly would be to the affidavit.
Okay.
And the affidavit goes through all of the disqualifiers that you would typically be asked for by a judge at a hearing. Have you ever been dishonorably discharged from the military? Are you legally and lawfully
So
in
it
the United
mirrors the
States?
form that they fill out when they purchase a firearm.
Correct.
The federal form.
Yes, it has all of the disqualifiers on it. So that affidavit certainly could have criminal consequences if they lied on it,
Sure.
because it would be perjury.
I'm just trying to determine whether or
But-
not they would need an attorney to get their firearms back.
No, and it's a very simple, straightforward form that just asks questions about, it asks the question of like, why your firearm was taken in the first place, like what kind of case it was. And then it asks basic information. There's nothing that
It's biographical.
yes, that a typical individual couldn't fill out by themselves.
Okay.
And we did it understanding that 99% of people who would do this are not going to be represented by an attorney when they do that
So it's
process.
designed pro se.
So it is designed for
Representative
self-represented
Scheer.
people.
A question as to your first concern. If, do you have the 1203 in front of you?
I unfortunately do not.
Um,
I apologize. I should
So
have.
the language
Yeah.
reads on line 7, starting on line 7, the court shall not request or conduct a background check and shall immediately order the return of firearm property. Your concern is that court may not know about everything that's going on with that individual in terms of possession of firearms.
Yeah, I would say not even may not, would not.
Okay.
Likely
So
not.
if that, after the word property, if the language subject to the restrictions other state of other state and federal laws, if that were added, would that cure that problem?
It would not cure the would immediately order problem. So right
Well-
now, I would make the argument potentially too that we don't necessarily need this because we already have a process in place for all return of firearms for everything.
Follow up?
Yeah, just go ahead, keep it.
I understand. This is a non-follow-up question.
Okay.
So your first concern seems to be moot, given the process you described in the second part of your presentation.
Well, if the language were in there that says we must immediately do it, then we would need to develop a new process on top of the new process we already have, because that new process just started January 1.
So last non-follow-up.
Yeah, go ahead.
If the word immediately were taken out of this, then you would be good with it?
Well, it certainly would alleviate the immediate, that issue of immediacy.
And
But
then your process could unfold.
Let me ask you this, Your Honor. If this were the pass, would you be able to get firearms out any quicker than you already are? In other words, would it fix a problem that doesn't exist?
right. If you took the word immediately out and you took the words of not running a background check out, we would presumably use the same exact process that we have
Yeah.
now,
Okay, that's
that we've just put into place.
Representative Lassell.
Thank you for taking my question. Operationally, once the litigant brings the form to the police department, how long do they have to comply with the order?
So I don't believe there is anything that specifies how long they have. All I can tell you is, and maybe Captain Muzzy could talk to this a little bit, but all I can tell you is that based on what I know, police departments want to get rid of things in their inventory rooms as soon as humanly possible. So that typically when they get court orders to give things back, that's usually the way they like to
Your
approach
Honor,
it,
so
but
if the
not
bill
my
were if the
purview.
bill were changed to just simply something that said that upon receipt of an order by the court, the police department will immediately return the firearms, This is probably going to be a question for Captain Muzzy to answer.
Yeah, that's going to be a
If we took the judicial part out of
Yeah.
it and just focused on how long the police departments take to return the firearms,
So I can't obviously
Right.
comment on that. That's
but
a,
that would alleviate your concern.
that's a Captain Muzzy question.
And he can only speak for the state police though, but yeah.
Yeah.
Yeah, go ahead.
So a couple things.
Here,
I-
give
I-
This isn't a hearing. This is very informal. Go ahead.
A couple things. I will just say currently, the way that 159D4 that took effect January 1st reads Section F. It says, upon receipt of a proceed response from the Department of Safety, the court shall immediately issue an order to return the property, which is happening. The order shall be mailed, which I think was a concern that came up last year. How does the litigant physically get a copy of this to get that process started? So currently it reads, the order shall be mailed to the law enforcement agency and the petitioner, and the court shall telephonically notify the petitioner that he or she may pick up the order at the court, and then it says, goes on to say, law enforcement shall accept the copy from the litigant in order to get the property returned. It doesn't speak currently to how much time the department has, or anything to that effect. What I can say from a police department side, not the gun line side, but as I think I started to testify last week, our detective sergeants at each of our troop stations are the responsible party that have access to the evidence room. So returning those immediately, well, what do we mean by that? You know, what if that person's on vacation? Obviously they have an alternate, but let's say there's some catastrophe that means no one can physically get into the evidence room for 48 hours. Is that reasonable? It might be in most cases. To say immediately,
Yeah.
I don't want to speak for every department, but that might be a little bit unreasonable. Something to the effect of, like a 48-hour window might be, and I don't want to say return them in 48 hours, but at least, let's say, make contact with that evidence custodian within 48 hours to schedule a return or something like that, so that something has to be done within 48 hours, but it's not necessarily the guns getting back, just to alleviate any anomalies where this person or persons may not be available physically to get to the evidence room, to get to the property, to return it.
We have heard though of situations where people have been, let's just say it blatantly, delayed. Be it for whatever reason, they just aren't a fun person to hang out with. There's a delay in getting their property back.
Understandable.
And their personality notwithstanding, their rights are to have their property back as soon as humanly possible. So, which is, I would say, the reason, the impetus this is in front of us today is because of things like that.
Sure.
So while I'm hesitant to put any kind of a time limit because I know exactly what you're talking about, they could be in the middle of an inventory and who knows. I would suggest though that within 7 days would be reasonable. If the evidence officer's on
Oh, I think
vacation,
7
I would
days is-
assume the chief of police has keys to the evidence
I
room.
would think 7 days is reasonable to account for any of the scenarios I've tried to describe.
Okay. All
Certainly.
right. And that's not necessarily what's going to happen. That's just
Sure.
something I'm spitballing. Okay. Yeah. Representative Prue.
I have trouble understanding that nobody has access to the evidence room for at least 48 hours.
That's not what I'm saying. Under normal circumstances, yes, certainly there's going to be somebody there. My fear is that if the law says immediate, what does that mean? In the next 10 minutes? Does that mean the next 24 hours? Does that mean when we get to it? So I guess I'm giving a real world example of trying to account for the
Yeah.
scenario where a lot of chiefs of police don't have access to the evidence room. So for obvious reasons, they want to maintain, limited access, right? So it's not always the chief. I mean, I suspect if there's a building emergency, that maybe there's somebody that can get in there.
I mean,
They probably
clearly,
have
do we need
alternates,
do we need a statute that says that at least two people or someone will always be present with access to evidence? I
but I
mean,
don't know that that's necessary because I think that's common practice.
It should
I'm
be,
just
yeah.
trying to, again, account for
no,
those
and I
scenarios.
understand.
So-
We understand what you're saying.
So 7 days, 5 days is not unreasonable to start the process, I would say.
Start the process.
Well,
What the process
to
should be?
have them
Here's the
returned in
order.
7 days, if you're talking about the book is closed, they're returned in 7 days, I mean,
Yeah.
I don't think that's unreasonable. I guess I just don't want to back ourselves into a corner where
Sure. Well,
now
what
the
is the
police
process
department's
that you have?
violating a law because they couldn't, for whatever reason,
Yeah.
huge anomaly, couldn't get them back within 7
When
days.
you say process, what is the process? You get the order right? I'm sure you have to enter something.
Sure,
And
they create
They signed
probably
for
a-
something
Yep.
and they're giving their guns back, right? There's no other process.
There is no other process.
Okay,
I'm just talking about the availability
Yeah,
of the
sure.
person or persons to be able to do that, which in theory, probably in most cases can take less than an hour, right?
Yeah.
To
I-
do everything, create the form that they sign off on and gather up the property and ready it for release or,
I think I understand what you're saying.
Okay.
Yeah, we're good. Okay. All right. Thank you both very much for coming in. Thank
Thank
you,
you.
Your Honor. We really appreciate it.
Thank you for the,
For our non-hearing. Yes,
I appreciate the opportunity. Thank you.
anytime. Thank you. Okay, with that, we're going to recess this executive session. We are going to take until, let me look at my watch. We're going to reconvene at 10:45 and both sides can caucus on the bills we have, what we just heard and what we have scheduled. I'm sure you haven't had a chance yet, so is that enough time? All right. opening the executive session on House Bill 1087. And I recognize myself to make a motion. I move inexpedient to legislate.
Second.
Seconded by Representative Peru. I'll speak to my motion. The sponsor himself, after discussion with myself and law enforcement, realized that this subject, if it's to be dealt with at all, it needs to be worked on, and it's not ready at all to be put forward. So we all agreed that it was probably best to just ITL it for now. Would you like to speak to your second?
No, I think you covered that.
Further discussion? Seeing none, ask clerk to call the roll. The motion on the floor is inexpedient to legislate on House Bill 1087.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative LaSalle,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Duchenier,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
13-0, the motion carries. Inexpedient to legislate. Any objection to consent? Seeing none, it will go on consent. I hereby close the executive session. I hereby open the executive session on House Bill 1203, and I recognize myself to make a motion. Wait a minute.
Yeah, we just.
Okay. And I move inexpedient to legislate. Seconded by Representative Harriet Gathright. We just heard from the court. We heard from law enforcement. What we didn't hear is any testimony, if I recall, during the hearing of anyone who had been particularly aggrieved. We heard that the court just spent a lot of time coming up with a process to ensure that firearms are returned in a timely fashion after a case closes. Where there may be an issue is with the timeliness of some, and this is not most, but some departments in getting the firearms back to the owner once the court issues it. That is something that we need to look at in a separate piece of legislation, if we have to look at it at all. But as far as the court system of ordering the firearms returned, it sounds like, based on the law that we just recently passed, the court took it seriously. They formed a commission, and they spent, I believe she said, 5 months. And now they have a system that's been adopted court-wide to ensure that firearms are returned and an order is issued. So I don't think this legislation is needed. Representative Harriet Gathright, would you like to speak to your second? Further discussion? Seeing none, I ask the clerk to call the roll. The motion on the floor is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative LaSalle,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Duchenier,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
Clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
13-0, ITL, motion carries. Any objection to consent? Seeing none, it will go on the consent calendar. With that, I close the executive session. I hereby open the executive session on House Bill 1413 and recognize myself to make a motion. I move inexpedient to legislate.
Oh, anybody else can have it.
Representative Murray, I believe, was
Yeah, I think
first.
so, too.
Yeah. I'll speak to my motion. We heard a lot of passionate testimony. I believe that there's people of good hearts on both sides of this issue. The bottom line is, in my mind, only 5 or 6 years ago, we decided as a state to do away with capital punishment. Things haven't gotten any clearer in the last 5 or 6 years. Actually, to the contrary, we have seen still people continuing to have convictions overturned based on DNA evidence. We've seen our government at different levels become more contentious and fractious. And in my mind, the state of this country, I don't think we want to empower government the ability to kill its own citizens. And that's where I come from, and I believe many others do as well. Would you like to speak to your second, Representative Murray?
Yes, Mr. Chair, thank you. I think there are so many reasons to oppose this legislation. You know, I have a moral objection to it, I have a fiscal objection to it, and when you look at the data, it doesn't do anything to deter crime, and in fact, it's not what most victims want in the case when they're pursuing justice. So yes, I support ITLing this legislation.
Further discussion. Representative Scher.
I support what both the chair and Representative Murray have said, and just with more detail, the homicide rate in New Hampshire is the lowest in the United States, number one. Number two, since the death penalty, the last 6 years since the death penalty has been repealed, there have been 101 homicides. In the 6 years before the death penalty was repealed, there were 102 homicides. So there's no evidence that this has any deterrent effect. And I was particularly taken by the number of family members of victims of homicide that said they did not want a death penalty for the person who killed their loved one. So I support the chair's motion.
Thank you. Further discussion. Representative Prue.
So, having a family member that was murdered and those people were prosecuted and went to jail without parole. We had mixed feelings at the time whether they should have been put to death or put in jail. And after hearing the testimony the other day, I was really sitting on the fence. And listening to all the evidence, it swayed me the other way. And I will tell you, the only time that I would entertain the death penalty is for a public safety officer. And yes, I know everybody's going to say, well, are they more special? Are they different? Yes, they are, because they are required to run to the danger, not run away like everybody else. So they get put in a really precarious position. Yes, it's part of their job, but I think there should be maybe some kind of deterrent. I'm not going to go looking for it, but I may not vote for it. I may. I'm not sure yet. But right now, as it stands, in general, I'm all set against the death penalty.
Representative Muse.
There were several of us who served on this committee when we actually voted to repeal the death penalty. I just want to thank all of the folks who weighed in online, who came here on person, who along with the rest of us have endured pretty horrible winter weather to get here and really spoke in overwhelming numbers. And I feel that with this bill and with this issue, we are your representatives.
Representative Chaborn-Deschanel.
We also heard testimony of an individual who had been on death row accidentally for about 30 years of his life, and that's a circumstance that we certainly want to avoid happening.
Thank you. Representative LaSalle.
I'd like to agree with everything that's been said and then there's one additional thing is in the case of Michael Addison, who there's no question he murdered a police officer. If there was ever a case for the death penalty, it would be him. And guess what? Here we are, years later. How much money have we spent? So in my mind, even when the death penalty is justified, it's not practical. It's simply not practical with respect to the court situation. So I will be voting ITL.
Thank you. In closing, I just want to add one thing, and this is something that stuck with me since I was 10 years old. When I first read J.R.R. Tolkien's The Lord of the Rings, and this is probably one of the wisest things that was ever written. And in it, one of the characters said, there are many who live who deserve death, and there are many who are dead who deserve life. Can you give it to them? If you can't, so quick to dole out that judgment. And with that, I would ask the clerk to call the roll. The motion is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
13-0 unanimous. ITL carries. Any objection to consent? Seeing none, it will go on consent. I close the executive session. What's up next? You may be correct. I think that the clerk will sort that out, but I think you're right, right? Yeah, no, thank you, Representative Scheer.
We had this issue come up in children and family law, and
Are you cheating on us? are you on a second committee?
I am,
Ah, okay.
but I love you all more.
But you tell that to all the committees.
At least today. Anyway, this came up in children and family law. The clerk, the chair checked with the clerk, and if it can go on consent if it's an ITL, because so it can go on consent even though it's an FN.
Thank you both for the clarifications. Mark it as consent, and there's a good chance it's going to get pulled anyway. But, yeah, maybe not. Where are we at? We're at 1576. Wait a minute. Did I close that one? I did. I hereby open the executive session on House Bill 1576, and Representative Paquette is recognized for a motion.
Yeah, I would like to introduce an amendment to this. It's amendment number 0366.
I
And
I second your motion.
I'm sorry.
That's
I'm
okay.
sorry.
Would you like to speak to your motion?
I would.
Go
Yes. What this does is there is some concern with the original bill. In what there was some penalties for intentional non-payment, and a lot of people came to me with that concern, and that wasn't part of the original bill. That was something Department of Corrections came to me to ask me to add on. And if that was gonna hold it back, I was perfectly happy to scrap that part, and everything that remains is still addresses all of the reasoning for the original bill.
I concur with what you just said. Does anyone further discussion on this, on the amendment? Seeing none, I'd ask the clerk to call the roll. The motion is to adopt the amendment.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
13-0, the motion carries. The amendment is adopted. I recognize Representative Paquette for another motion.
Ought to pass. As amended, I'm sorry. OTPA.
I second that. Would you like to speak to your motion?
Sure. What this bill as a whole is doing is it's bringing back rights to victims. So as of right now, victims of crime are not getting the restitution that they were court ordered in a timely manner. They're not getting the communication that they deserved via the Victims' Bill of Rights, and this rights all of that.
I agree with everything you said. Further discussion. Representative Lascelles.
I would just like to compliment the representative for bringing this bill, and it, based upon the testimony that we received, I think, my gosh, this is very much needed. So I intend to vote aye.
Thank you. Further discussion. Representative Scheer.
I like this bill. I think it's really important. I'm particularly pleased with the amendment. As we heard, there are going to be significant staffing issues. I don't know how this bill will fare in House Finance, but that's not for us to decide. We're a policy committee, not a money committee. I am concerned about what will happen in House Finance.
Thank you. Further discussion? Seeing none, I ask the clerk to call the roll. The motion on the floor is ought to pass as amended with amendment.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
Motion carries, ought to pass with amendment. Any objection to consent? Seeing none, it'll go on consent. With that, I close the executive session. We are going to take 15 minutes to allow the minority to absorb the amendment I just handed out on 1587, and we will be back here at 11:30. I'm opening the executive session on House Bill 1587. As you saw, there was an amendment handed out. That amendment, I have had certain discussions with law enforcement, and it needs some more work. And in that time, I'm happy to take input from anyone else. But I'm going to recess until we're ready to sort that out. Yes.
I also filed an amendment that I circulated.
Yeah.
I think we can proceed on my amendment now.
No, we will entertain your amendment when we take the bill back up. I will at that point.
Yeah, I would add one more thing, and I direct this to the representative for the counties. I find it disrespectful and offensive that we get these last-minute amendments. This bill has been around for a while, and, you know, if this kind of behavior continues, I'm always going to vote against any last-minute amendment by like this that is submitted. So to say the least, I'm really pissed off that we get this at the last.
I would ask you to take caution with your tone. You just handed me an amendment 5 minutes ago that you handed out, that you came up with. So let's not start.
I sent you that amendment last week.
I didn't see it. Regardless, I just got that amendment printed by the county. I think she sent it to me days ago. We have hundreds of amendments coming in here. If we're going to take issue with people handing us amendments, we're never going to get anything done, because I think I've got 4 here that I've just seen for the first time this morning. So it is what it is. It's a messy process of making this sausage. In any event, we will take up your amendment first when we reopen the hearing, which gives us all time to read your amendment and to come up with suggestions if you have them for the other amendment. With that, that is recessed. Next up, House Bill 1595. And I recognize Representative Rhodes for motion.
Thank you, Mr. Chairman. I move ITL for House Bill 1595.
Second.
Seconded by Representative Prue. Would you like to speak to your motion?
Yes, I would. Thank you, Mr. Chairman. This bill is not an easy bill to absorb. There's a lot of moving parts. And unfortunately, although the sponsor's intentions were very well meaning, even she has recognized that the bill is not able to be passed as it is. And I really just don't see the reason to interim study. Anything that can be done during an interim study can be done from now until refiling period. So, and she actually didn't even give testimony on the bill. So with that, I just move that we do away with it.
Representative Prue, would you like to speak to your second?
I think Representative Rhodes covered it quite clearly.
I would add to Representative Rhodes, interim study would require us to come back in the fall and make a decision on the same bill that's in front of us, or rewrite it to be refiled with the new filing period. So I don't see the necessity of us coming back to refile a bill that can be filed by a sponsor at the exact same time. Further discussion. Representative Muse.
I do want to say I'll be supporting that recommendation, but I also wanted to say that there are some good things in this bill. There are definitely some good things in this bill. One I just wanted to point out is the requirement that law enforcement officers complete a lethality assessment program form. This is something that isn't consistently done across the state. That really should be a standard operating procedure. There are other things in there. I do hope as we go along and we look at some of the other bills regarding domestic violence that hopefully we can take an approach where with this bill we're saying the window is too big. I think with some of the other ones the window may seem too narrow, but if we reject the narrow ones out of hand, we may not make as much progress as we'd like to, when it comes to domestic violence issues.
To address the LAP program, you'd be happy to know yesterday the state law enforcement accreditation commission met, and I brought the LAP program up, and it is on the agenda for next month's meeting as to whether or not to include it as part of the accreditation process to ensure that it is. Currently, the Attorney General advocates its use at every police department. So if we add it to the accreditation process, a department will be judged on whether or not that is part of their process before they can get accreditation. So I think that's probably better than putting it in statute in case it's modified or changed or a different, because that actually I found out is a copyrighted product owned by a company in Maryland, the actual lap itself. So I'm always hesitant about mandating a certain product, but putting it that way, at least if it's modified, we can quickly change it in the accreditation process to whatever is adopted. Further discussion? Seeing none, I'd ask the clerk to call the roll. The motion on the floor is an expedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative LaSalle's,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
Any expedient to legislate, any objection to consent? Seeing none, we'll go on consent, and I close the executive session. All right, next. Wasn't this what we just talked about? Yeah. Hereby open the executive session on House Bill 1632 and recognize myself to make a motion. I move an expedient to legislate.
Oh, second.
I'll speak to my motion. I think I just really spoke to it a second ago. With regard to this process, currently the Attorney General, if you go to their website, it has the LAP program, and it talks about how it instructs police departments in the state to use it. It's not statutorily mandated. As a member of the Law Enforcement Accreditation Commission, yesterday I brought it up, and it's been put on our agenda for the next meeting, and we're going to vote on, after we hear from people we're going to invite to talk about it, whether or not it should be included as part of the accreditation process for any department in the state that seeks accreditation. The assessment tool has proven to be a good product. However, I have concerns regarding mandating the use in statute of a copyrighted product. I would rather that the departments make the choices to do so, and we highly encourage it through making it part of the accreditation process than mandating it. Would you like to speak to your second?
No, thank you.
Further discussion?
Sure.
Representative Muse raised his hand first.
We do have a proposed amendment that essentially would create a study committee to look at this issue. One of the things about using a copyrighted sort of a standard input form is that while the input mechanism may be copyrighted, the information that goes into it is not, and that information is valuable when it's shared. So understanding, and I understand completely where you're coming from on this, and I think that the work that you've talked about is good work and absolutely should continue. But I do think that there's an open question about where something like this, regardless of what we call it, may or may not fit into statute that a study committee could help us address. So I'd like to propose that. And there's an amendment in front of us now that would actually convert this entire bill into a study committee that would do just that.
Thank you. Further discussion? Representative Pro.
So I agree with not locking into a certain one, because in another organization that I'm in, we got backed into a corner, and that organization changed the way they function. That's going to cost us a lot of money. So having something similar, likewise, or something like that is a better way to go.
Thank you.
And,
Go ahead.
and I don't think we need a study committee to do that.
Thank you. See no further discussion. The clerk will call the roll. The motion is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative LaSalle's,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
13-0, motion carries and expedient to legislate. Any objection to consent? Seeing none, no go on consent. That I close the executive session. I open the executive session on House Bill 1633 and recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ought to pass for House Bill 1633.
Second. Would you like to speak to your motion?
Thank you, Mr. Chairman. When a sexual assault survivor presents themselves to a police officer, an emergency room, family member, friend, regardless, to say that the emotion that that person is experiencing is overwhelming would be, I just don't know that there are words for it. However, anything that can be done to make it just a little bit easier for them at that given moment, I think that we should do. And the bill in front of us is, not asking a lot. It's asking that people that are in situations to give information to that person at that exact moment, that they do that. Also, it's asking that information be put up on the website as well. And I will tell you, from happening to deal with different agencies in the state, for how small of a state we are, boy, we have a lot of government. And oftentimes I'm not able to find what I need, and I'm a person that should be able to do that. So this is basically just expanding the information that is given and expanding where it's available to be given. And there's one small typo that I do believe can be cleared up. I think it's just an A needs to be put in there, but I think that can be taken care of.
Yeah, I think that can be the scrivener's error taken care of. With regard to my second, I just concur with everything you say. I would actually like to see it posted somewhere at the entrance to emergency facilities. The same way they take the time to put a sign up that says no firearms allowed, they could also put a sign that says inquire if you are a victim of sexual violence. But it's not in this bill, but it's something I think would be worthy of talking about at another time. Further discussion? Seeing none, the motion is, oh, go ahead. I'm sorry, Representative Murray.
I definitely support the intent of this bill. I think I just have some concerns with the logistics of it. And also I feel like I shouldn't have to clarify this, but I am a victim. So I'm someone who's been in this position before. So I'm making my statements based off of that. But we're told that when someone declares themselves to be a victim, that an advocate is called and the advocate is communicating that information with someone. So I guess I'm like a little unclear on like where the gap is here. Also, not to say anything to our vice chair, who I respect very much, but I did find the DOJ Sexual Assault Bill of Rights and booklet very easily. And I do think it's not that hard to come across. So I think I just wish there was time to maybe intentionally amend this a little bit more. I also think it's like not in the right RSA, for example. But for these differing reasons, I am going to be objecting to it, even though I do agree with the concept of the bill.
Thank you. Further discussion? Seeing none, I'd ask you to call the roll. The motion is on to pass.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harry Gathright,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Murphy.
No.
The clerk votes no. Representative Shear,
No.
Chairman Roy,
Chair votes yes.
7-6.
7-6, motion carries. It will not be on consent, obviously. With regard to reports, what is today? Please have them to me no later than Friday, wherever that is. With that, I close the executive session. Up next, we have 1641. Yes, I open the executive session on House Bill 1641 and recognize Representative Saborn Deschanel to make a motion.
Thank you, Mr. Chair. I move an expedient to legislate on HB 1641.
Seconded by Representative Rhodes. Would you like to speak to your motion?
Yes, sir. This bill was relative to another attempt at bail, and we just took care of bail reform last year, and so we're going to leave it with how we left it last year.
Representative Rhodes would like to speak to your second.
Thank you.
And further discussion, Representative Murray.
Thank you, Mr. Chair. Just to build off my colleague's point, I think it's important to remember that a lot of the legislation we pass in this committee doesn't take effect until the following year. So oftentimes people are introducing more changes and amendments to statute that we haven't even seen the effects play out yet. So I very much agree that it's not the time to continue to make more and more changes to bail. We need to let the system kind of catch up with the changes we've made so far. We need to implement the, data sharing that we've talked about, and then we can make adjustments once we actually have data to look at how these things are working so far. But I think it's too soon to make any more changes.
Concur. Thank you.
Thank you. And I wish we'd have heard that like an hour ago while the judge was still here, because I had a question about what happened to the money we sent them with regard to data sharing. And I think perhaps we will send a letter from the committee requesting that information. Representative Scheer.
As I recall, just maybe some confusion. As I recall, that we allocated that money to Department of Safety to set up that system, not the court system, or in conjunction with the court system. So I think letters need to go to both places.
I think if I recall, we split it. There was some money that went to each. So yeah, I agree. Further discussion on this bill, though. Representative Muniz.
I would say that this is a policy that we essentially agreed to and funded as a committee a couple of years ago, and the fact that it hasn't happened yet is an issue. Rather than ITLing it, I would suggest perhaps interim studying it, because I think it's important for us to keep this issue alive and in front of people, certainly alive and in front of the legislature. Not all of us are going to be here in the next session of the legislature, and we could still have this problem. And this may not be the best opportunity to fix it, kind of right where we are now, but I think interim study would send a message that we think it's a problem worth fixing.
Thank you. Representative Murphy.
Thank you, Mr. Chair. I agree with the points that you made. I'm especially concerned about the lack of communication between and the funding that was provided to address this issue. One of my other concerns is the online 5. It was relative to the clerk's office transmitting orders within 24 hours, excluding any weekend or holiday. And I think when you play that out, it could be 4 days of if something happened on a Friday. Could be a long lag time between when those orders were transmitted. So it could be 4 days, which I think we should look at. So I agree with the points made.
Thank you. With regard to the interim study suggestion, I guess I would go back to the same point that because it's the second year of the biennium, we would simply reissue a report suggesting the legislation be filed again. We could do the same thing anyway if we wanted to refile it. I think that if we, before we finish our work here, perhaps while in between, before crossover, we could circulate a letter to the courts and the Department of Safety requesting feedback on what happened to the funding. And maybe we can get an answer before we break for the term. And if we don't, we could always reintroduce the legislation, whoever of us happens to be here next year. Or any of us.
I'm going into hiding.
The motion on the floor is an expedient to legislate. I'd ask the clerk to call the roll.
Vice Chair Rhodes?
Yes.
Representative Prue?
Yes.
Representative Lascelles?
Yes.
Representative Devoid?
Yes.
Representative Paquette?
Yes.
Representative Saborn Deschwanier?
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
No.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
12-1.
12-1, do you object to consent? Okay, so it will not go on consent.
So that was 12-1.
Yeah, 12-1, motion carries in expedient to legislate. I close the executive session. I open the executive session on House Bill 1686 and recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move in expedient to legislate for House Bill 1686.
I'll second that.
Seconded by Representative Prue. Would you like to speak to your motion, Representative Rhodes?
Yes, thank you, Mr. Chairman. Again, while well-intended, every vehicle is equipped with a speed assistance device. It's a speedometer. And this bill not only, has fines that are going to put the person in a financial bind, and who's going to pay for this device if they don't have the financial means to do it? And I fear it's going to be us that's going to be paying for that. And I can assure you, I may or may not be speaking from personal experience. If you get one ticket going at a speed that is listed here, you slow down. I'm telling you all, you do. And for a little while. So anyway, with that being said, I just think that the unintended consequences here are greater than what it's trying to do. And Representative Muse had mentioned last week about a lot of these bills we're seeing that were here, 4 and 5 years ago. And there was a bill similar to this about DUIs. And that had so much discussion because what happens whenever you have shared vehicles, what now the other person that may be using that vehicle is, going to be hindered from something that somebody else did. So for those reasons and many more, I'm moving ITL.
Would you like to speak to your second, Representative Prue?
So I agree with Representative Rhodes. I know I use my cruise control a lot, so I don't speed. So I think this is unnecessary and it will be a burden, right? And some company trying to make money. That's what I see. I know there's been problems with the alcohol interlocks. They don't always work. So in emergency services, sometimes you might need to drive a little bit faster. You have a medical emergency in your car. You want to get off the highway. You want to get to a hospital right away because it's going to be quicker than waiting for the ambulance. That might be an issue. So in your vehicle not being able to respond to that, I think could be a life threat.
Thank you.
Oh, I didn't think of that.
Representative Murray.
I didn't think of that.
Thank you, Mr. Chair. I agree this bill is not written in a way that I think is passable right now, but I did just want to highlight, the testimony from people that came to share their experiences with either death or near death experiences from the amount of speeding that's happening, on the highway, but also in our local neighborhoods. And honestly, I think one of the biggest lessons I've learned since joining this committee is how horrible our statistics are when it comes to traffic safety and traffic deaths right now. I think just this year alone, I've had multiple friends get in accidents for a variety of reasons, many of which are not their fault. And I do think this is an area that we need to figure out how we can better address it. I don't know if it's penalties or education or what, but it is a sincere issue, especially in a place like Manchester where I live, where people, flying down Beach Street or whatever it may be, double the speed limit at least. Anyway, I agree this isn't ready for prime time, but I would like to see us continue to focus on this issue.
Thank you. I would suggest the mayor perhaps call the state police, who would be happy to send in some folks to help them with some targeted speed enforcement. Representative Scher.
Speaking as much as the chair of the Portsmouth Police Commission now, speeding is the #1 complaint the police department gets. And we've spent a lot of money in terms of speed bumps, speed tables, all sorts of speed things. And
Speed humps.
I agree with everything that Representative Murray said.
Thank you. We just passed, I think, a couple of bills last term with regard to speed. I think the 100-mile-an-hour bill we just passed. So we're going to have to, no pun intended, slow down. Let's see how the enforcement statistics come out for the next year, and look at different and targeted ways. But these machines and this instinct that seems to happen where we're trying to electronically invade and control is really just creeping me out. I don't like, we just saw in Congress, the United States Congress, they authorized some kind of kill switch to be put into vehicles or mandated it. It's getting a little much, and that's something we need to watch out for and push back on wherever we can. Otherwise, they're not really our vehicles if someone else can control them at the end of the day. Representative Muse.
Yeah, I would say that before we put something like this in statute, something that might be a better idea would be to maybe create some type of pilot program, and maybe this could be done through the Traffic Safety Commission. Because at this point, what we really don't know is which is behaviorally more effective and would have the biggest impact, just continuing with suspension or offering some type of a program like this available as an alternative. If there was some sort of pilot program, then there would at least be some data and some cases that people could look at that would make a determination that would be driven by data, not necessarily by talking points at public hearings. So I'm going to support the recommendation.
Thank you. Seeing no further discussion, ask the clerk to call the roll. The motion is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
Any objection to consent? Seeing none, it'll go on consent. The motion carries inexpedient to legislate. I close the executive session. I hereby open the executive session, House Bill 1730, and recognize Representative Rhodes during the motion.
Thank you, Mr. Chairman. I would like to introduce Amendment 2026-0420H.
Second. Would you like to speak to your motion?
Yes, thank you, Mr. Chairman. So this bill came to us as yet another death penalty bill. And the amendment does away with all of the death talk. I do not know what the solution is, quite honestly, for pedophiles. And some of the people that I've spoken to in the prison system said that there really isn't any rehabilitation for them. It's a lifetime illness, and there's just no cure. However, the statute that I'm looking to amend, the bill that was in front of us had to do with death penalty for sexual assaults for minors, etc. So we found that the statute that we are addressing has somehow been overlooked for 20 or 23 years. So what we're looking to do is in 632A, that violation, that crime is still a misdemeanor, and we are going to make that a felony. And the reality is, if you are in a position of authority over a minor, to say that that minor consented is never acceptable, and that's already been found to not able to be, I guess I want to say, an excuse. So we are going to change that. We're taking out the words, uses his or her authority to coerce the victim to submit, and we are making it be a felony.
Thank you. I would, as for my second, say that in a situation like that with a power imbalance, the person who is on the lower end of that imbalance is never able to consent. It's not within their power to consent. And as such, that person is taking advantage of both the victim and the people that put them in the position of authority over that victim. And as such, that is clearly within our normal statutory scheme of what constitutes a felony. So I support it. Further discussion, Representative Scheer.
I guess I'm confused. We just got this morning. I'm confused and aware, in reading the amendment, I'm confused where number one, I'm confused where it makes it a felony. I just don't, all I see is the amendment eliminating a language and uses that authority to coerce the victim to submit. And I just maybe, because I'm old, I don't understand where it makes it a felony, number one. Number two, because I oppose the death penalty, I'd love to get the answer to the question from Representative Rhodes, but two, I'm going to support this amendment so we can get rid of the death penalty. But I am, unless I can figure out why it makes it a felony as it's written, I'm going to oppose OTPA. So just for what it's worth.
Thank you. Representative Rhodes?
I believe, so I may need to stand corrected. 632A4, 632A4, I believe, is where it's making it be a felony. However, if I am wrong, if it's possible, if we could recess and come back to this one, so we can just clear that up. That because I certainly don't want to give wrong information, but I don't think that I am.
Yeah, as I look at 632A4, it says it's a misdemeanor, but all you're doing from A4 is eliminating using the authority to coerce the victim to submit. You're not adding it to another provision that makes it a felony. That's how I read this. Again, I may be wrong too. I just don't I haven't figured it out.
Hold on a second. The representative from the coalition may have some insight. I believe she worked with the attorney Enders and Representative Rhodes.
Yeah, I have now, and the book that I have is is the most updated, but I do think there might be one that is more. So
I looked at the legislative history, and so in 2003 they looked at doing this exact same thing. At the time, there were a couple scenarios that I think later amendments have now addressed, the scenarios that they were concerned about that had them put in the submit to coerce language. And so 32A2 and 32A3 are both addressed in 32A4 separately. So one of them has sexual contact and one of them has sexual penetration. The only difference between these three sections in the statute is the coerce to submit. And so when you remove the coerce to submit, that'll absorb the misdemeanor into those two provisions. So I think I hope that makes sense, but that's the main distinction between these three sections of law, is that one is penetration, one is sexual contact, and the misdemeanor is both sexual contact and penetration without the coerce language. But all three already have consent cannot be a defense, and all three have the position of authority language. So my understanding is that this amendment absorbs what distinguishes the misdemeanor from those two felonies. And the reason why it looks like it's not doing anything is because when you remove the coerce to submit language, that alleviates sort of the distinction between the misdemeanor and the felony. I'm happy to get more information to the committee. But I
I'm going to need more.
That's fine.
My understanding of statutory construction is you can't just automatically assume because you took something away, it bumps it into another section totally.
It's
Representative Scheer,
identical language except for that. So that's the only distinction between it. So but yeah.
Representative Scheer.
Yeah, I'm looking at A2, and A2, I agree. A2 talks about penetration. A4 talks about contact. But by removing the submission language from A4, that doesn't mean it's absorbed into A2 because
Yeah.
it's still contact and not covered by A2. So
No.
I just don't think this, I'm not sure
Yeah.
that this does what we want it to do.
I think I'm happy to just I'm happy to discuss it further because I think it's confusing because A2 and A3 are addressing two different parts of A4.
Yeah, I
So-
think what we need to do is make it clear, and we're just going to recess it, and we'll pick it up again with an amendment that clearly puts it in the felony. Representative Mead.
Yeah, Mr. Chair, I would just say that, you know, this clearly started life as a death penalty bill. We had literally thousands of people who came and testified one way or the other on this thing. While I understand the need to address the issue we're talking about in the amendment, it's the kind of issue that could have been addressed in a completely separate bill. Frankly, I would just like to see us rule on the original bill as it was. I think the other thing is this is a fairly complicated legal issue that I'm not sure all of us really adequately understand enough to be able to make an intelligent ruling one way or the other. I'll speak for myself there. I don't feel like I really understand this part of the law well enough at this point.
Which is why I'm recessing, and you're going to have a couple of days to study it up, and you'll know it quite well. And I think that anyone who's watched the previous bill realizes where we're going, and clearly the death penalty has been removed from this, so anyone who had angst over that should be mollified until we take it up again. We recess. Next. Why is his name there? 1730. Relative to the death penalty of certain offenses. Oh, yeah. I hereby open the executive session in House Bill 1737. Recognize myself to make a motion of inexpedient to legislate.
Second.
Seconded by Representative Rhodes. I don't want to belabor the point for all the reasons that I felt that we should not adopt the previous bill regarding the death penalty. They all apply to this one. There's no difference in my mind what the charge is. The fact is the penalty I do not think is appropriate for any charge for our government to be executing its citizens. Representative Rhodes, would you like to speak to your second?
No, thank you.
Discussion, Representative Scher.
Very briefly, in previous legislation that passed the House, we made certain offenses against minors under the age of 13, the sentence of life without parole sentence. So number one, and number two, this particular bill, there are over the fiscal note identifies that there are over 200 of these kind of charges that happen every year. So it would be hundreds of millions of dollars for this death penalty, to have death penalty trials on all of these.
Even if we were amenable to the death penalty, we couldn't afford it, which is discouraging. But yes, you are correct. We just passed a bill making it life and eligible for hard labor should a jury determine that it was worthy of such for sexual assault under someone under the age of 13. So further discussion. Seeing none, I'd ask clerk to call the roll. The motion is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Scheer,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
13-0, inexpedient to legislate. Any objection to consent? Seeing none, I'll go on consent. And I close the executive session. open the executive session, House Bill 1740, and recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ITL for House Bill 1740.
Seconded by Representative Harry Gathright. Would you like to speak to your motion?
Yes, I would. Thank you, Mr. Chairman. The particular statute that we are discussing, I think it's 159, I might be wrong. It is-
173B.
Thank you. That is a particular statute that is working for thousands of women and men across the state. If we pass this and essentially rewrite the entire statute, we would be effectively disenfranchising the funding that is available to the organizations that help the victims that are in these situations. A person that has suffered domestic violence or sexual assault for many, many reasons does not always immediately go to law enforcement for help. And especially if it's a domestic violence situation. So saying that you have to first have criminal charges filed in order to have protection is just really going a step backwards. And we have to remember who the statute is written to protect. And at the end of the day, that should be our core focus at all times. And for that reason and many others, I ask you all to support the ITL motion.
Representative Harry Gathright, would you like to speak to your second? Thank you. I'd add that we also need to focus on the constitutional rights of our citizens. I think there's a delicate balance. I think the current statute meets it, but there are areas where people have had legitimate concerns, and I think that if that is a topic that is going to be looked at, it should be looked at with a microscope and operated on with a scalpel versus a hammer. And I agree with I'll be supporting the ITL. Further discussion. Representative Murray.
Thank you, Mr. Chair. I just wanted to emphasize everything that's been said so far. I think any changes to the statute have to be done really intentionally and carefully, and this feels like throwing the baby out with the bathwater, so to say, especially considering how much of a problem domestic violence is in this state. Over 33% of New Hampshire women have experienced intimate partner physical violence. Over 52% of homicides are related to domestic violence. This is a serious problem in our state. I think overall we're a pretty safe state, but I do think domestic violence is a huge sticking point for us. So I think it's good that as a committee, we know that such sweeping legislation is not the way to go about this. If there are constitutional concerns, of course, those should be addressed, but this is one area where I absolutely think we need to be prioritizing victim safety when we are looking at the reality of what is taking place in the state.
Well said, and I just got to congratulate your grasp of statistics today is overwhelming. Very, very impressive today.
Good with that iPad.
Yeah. Well, no, it's good. I mean, but between her and Representative Scheer, the numbers coming at me.
Don't put me in the same boat.
It's just the math.
Thank you, Representative Murray.
Before this gets ugly, I would ask you to call the roll. The motion is an expedient to
Oh,
I'm
I-
sorry, Representative Scheer. Not Scheer. Representative Deschutes.
I want to say I appreciate everyone's consideration on this legislation. Obviously, a full chapter reform is a very big lift. And again, there are some folks who have been hurt by the current statute. We did hand out the 4 case studies of Lindsay Smith, Destiny Berard, and a few others, and you all received those today. I can understand why it might be too much too soon. I think it might be worth studying. I know we mentioned we could look, instead of using a sledgehammer, maybe look at it with a microscope later. But I just want to say I appreciate everyone's consideration for this. Thank you.
Thank you. And as I never discourage anyone from bringing forward a proposal. That's why you're here. You just have to have thick skin and realize most of our proposals end up in the circular file, including my own. So it is. I'd ask the clerk to call the roll now and expedient the legislation.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative LaSalle,
Yes.
Representative Devoy,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Going to say no.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
12-1.
Do you object to consent? Okay, it will go on consent then. That means you don't have to get up and speak as to why. Yes, sir. Representative Scheer.
I figured out 1730 in the amendment, and I think it can be explained pretty easily. So before we end today, can we come back to it?
Yeah, if
Yeah.
you think it doesn't need further amendment?
No.
Okay, well, we can, we'll talk about, we'll take 5 minutes to talk about it after we do the last bill. Okay, so I closed the executive session on House Bill 1740. I opened the executive session on House Bill 1749 and recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ITL for House Bill 1749.
Second.
Yeah, too late. Representative Harriet Gathright got that one. Would you like to speak to your second?
Yes, I would.
I mean, your first, your motion.
We obviously, there's not really much to say on the death penalty, but I would like to say this. A victim wants justice. A victim wants to be made whole again. The sad reality of the situation is chances are good that they will never be made whole again. And as a person heals from these horrendous crimes, as the family member heals, the pain softens just a little bit each day. And at least that is the hope for them. So while these sound like a great idea when you're really angry, the fact of the matter is the person really ever going to be actually put to death? Probably not. And the appeals are never ending. They are absolutely never ending, meaning that the victim's recovery is really never ending because they just continually have to relive it. And until the system, you have one chance to get it right when you're the victim. And when you're the perpetrator, it just seems like you have endless opportunities to tell your story again and again to get a different outcome. So for those reasons and all the other that we heard today, I would ask to support me in the ITL motion.
Thank you. Representative Harriet Gathright, would you like to speak to your second?
Yes, we had heard a lot of testimonies against the death penalty, but the one that hits me the most is the number of people that have been exonerated, and the fact that many of them were of color. So when we get it right in how we treat one another, everyone the same, then I would even think about it, but I doubt it.
I still won't think about it, and I still insist that
Yeah.
I have a color. Representative Scheer.
Three things. Number one, something that Representative Rhodes said that caught me. One, that when a family member is killed, and there's a deep amount of anger. We have made efforts for centuries to mete out justice not based on anger and emotion, but based on something beyond that. And point number one, we're still working on it. Number two, I refer you all to the Ray Buchanan case that former Attorney General McLaughlin described, where they came this close to charging somebody with a death penalty offense and maybe executing that person based on the 8-hour interrogation of a woman with some intellectual challenges. But for the existence of forensic DNA evidence, which exculpated the person she identified, he may well have been subject to the death sentence. And we know statistically that over 90% of all homicide cases do not have biological evidence in them that is subject to forensic DNA evidence. And last, I'll never forget the testimony of Paul Hildewen, who was incarcerated for 35 years and then exonerated and survived 5 bouts with cancer.
Thank you. I also, it just occurs to me, this should terrify more of us as well. Imagine someone being convicted and sentenced to death based on some video evidence that now a teenager has the ability to fake beyond the ability of many people to tell. I'm very concerned for our court system as to how we're going to continue to weigh audio, video evidence going forward with regard to people's freedoms. And when you talk about the ultimate penalty, to find out that something was a fake afterwards would just be, it would be inexcusable for us to even entertain it. Representative Eric Gathright.
Yeah, it's not something that I talk about often, but we lost my brother-in-law to murder. That was back in the 70s. And even to this day, it is still painful. Okay, it's still painful for the family members. There's 7 siblings to the mother and to the in-laws and to my children of losing their uncle. But none of us has ever wished anyone to be put to death for that reason, you know, because of what they did to Eddie. That was his name. But, you know, we miss him dearly, but each day is better. So I have to agree with Rep. Rhodes that each day, each year, each occasion is always better.
Thank you for sharing that with us. Anything further? Seeing none, I'd ask the clerk to call the roll. The motion on the floor is inexpedient to legislate, and we'll vote inexpedient to legislate for Eddie.
Vice Chair Rhodes,
Yes.
Representative Prue,
Absolutely.
Representative LaSalle's,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
Any objection to consent? Seeing none, we'll go on consent. I close the executive session. We're just going to take 10 minutes and we're going to discuss that one bill. And if we can come to an agreement, we'll take it up. If we can't, we will we'll close for the day. So 10 minutes.
Yeah.
Camera bill, right?
Yeah. No.
Nope.
No. The death penalty where I changed.
Oh, yeah.
Yeah.
Bill 1730. And I recognize, wait a minute, I need a refresher.
We already introduced it, so we
Just, yeah, open it back up.
Okay, we're just going to move to a vote. I believe that everyone discussed it and clarification was given and understood on the status of the current law. So I would ask the clerk to call the roll. No, no. We already adopted the amendment, or is it?
No, we didn't vote.
Okay, so this is a vote to adopt the amendment.
Yes.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
The amendment is adopted. I recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ought to pass as amended for House Bill 1730.
Seconded by Representative Harry Gathright. Would you like to speak to your motion, or are we all set?
I think we're all set if you guys are.
Yeah, good. All right. I ask clerk to call the roll. The motion on the floor is ought to pass as amended.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
13-0, the motion carries. Any objection to consent? Seeing none, it will go on consent. With that, I close the executive session. We are tomorrow in House session. We're back on Friday. I'm going to schedule, just for everyone's notice, I'm going to schedule meetings next Wednesday and Friday. We probably won't need Friday, but we'll cancel it Wednesday if we finish our business. I believe we should be able to be done all of our bills, everything, by then. So right now, we're in the lead of all the committees. What's that? We are meeting this Friday, yeah. We
Do
still,
we know what we're gonna, is it in the calendar what we're considering this Friday?
this Friday's already been scheduled, I think, hasn't it?
Has it?
Oh, it has to be, yeah. Yeah, and there are certain bills listed, correct?
Matt, you owe a
No?
There's no
for
1641.
1641.
Yeah.
And Kathleen, you owe for your bill 1576.
Yeah.
All
So-
the rest are Terry and I. Wish us luck.
And then
With regard to Friday, I'll look and see, I'll talk to the clerk and see what we still have open, and I will compile a list by tomorrow for us, so you're prepared what we're going to talk about on Friday. Whatever, it's going to be early bills that we haven't dealt with, so they have to be out by Friday.
Could we meet at, just thinking about it, since we haven't caucused on whatever's going to be on Friday, could we open the session at 10:30 on Friday rather than 10?
No, it's scheduled, once it's in the calendar, it has to be, but I'll open it and recess for 30 minutes. Again, that's no problem at all.
Yeah, you don't have to drive from Portsmouth. Right.
You guys are having your,
My police department.
your police department is having an accreditation today, is it not?
Yeah.
Congratulations.
I was not aware that Representative Prue was in Portsmouth yesterday, so otherwise, who knows what would have happened.
Yeah, and I wasn't
on either side of the road
there. Okay.
And then that drone bill.
Shockingly.
Well, everything by Friday, because they're going nuts up there.